Welcome back to the deep dive. If you want to understand power in the Roman world, you don't just start at the Forum or the Senate. Really, you start in the courtroom.
That's right.
Our listener today wants to peel back the layers of Roman justice, moving beyond, the simple historical novelty of the laws to see the system as it truly was, this elaborate, sophisticated, dynamic, and, well, profoundly political engine.
Absolutely. It was all about politics, often.
We are talking about high-stakes legal combat where the rules were constantly being reinterpreted and the outcome often depended entirely on your social rank.
That's really the core of our deep dive today. Our mission is to synthesize the true mechanics of Roman procedure. We'll show how legal knowledge itself was a competitive battlefield,
Okay.
how magistrates like the praetor invented new remedies when the old law failed, and perhaps most importantly, how the entire apparatus of accusation and penalty was shaped by social status,
Right.
turning the legal process into this dramatic and often terrifying political tool.
A system where the rule of law and the rule of status were just constantly colliding.
Honestly, yeah.
We have some incredible detail in our sources on how that collision played out.
Indeed. The sources are quite vivid on this.
Okay, let's unpack this. So when most people think of Roman law, they probably think of, the foundational texts, primarily the 12 tables.
The 12 tables, exactly. That's the starting point everyone learns.
But what our sources immediately reveal is that the moment those laws were written down, they began to change. Not really by amendment, but by this continuous interpretation. The law, in essence, was alive.
It absolutely was alive because it was constantly being, well, rebreathed into by the jurists. The real engine of legal growth wasn't so much the legislative process. It was the ongoing commentary known as the responsa prudentum, the answers of the learned in the law.
Right, the responsa.
Yeah. These were the explanatory glosses, the interpretations provided by expert jurists on authoritative written documents, especially the 12 tables, at least initially.
So these jurists weren't just defining the words in the tables, they were essentially modifying the law itself, but kind of claiming they weren't.
That's the fascinating part. They maintained this legal fiction that the original code remained pristine and unchanged, sacrosanct even.
Okay.
But in practical reality, the published collections of these expert opinions constantly modified, extended, limited, or, practically overruled the original provisions.
So the law stayed the same on paper.
Exactly,
Yeah.
on paper.
Yeah.
But its application and meaning shifted dramatically based on whatever the prevailing juristic consensus was at the time.
I find it really intriguing that this intellectual competition actually fostered legal growth. It wasn't like a single supreme bench just dictating policy from on high.
That's not at all.
This was more like a free market of legal minds all competing for influence.
That competition was absolutely key.
Hmm.
Our sources draw, a very close and very instructive resemblance between this Roman system of case law and commentary and the development of the English common law, actually. In Rome, the growth of principle was fostered by this competition among legal expositors.
Yeah.
If a jurist responsa was, say, better reasoned or more adaptable to current needs, it gained wider acceptance.
And then it effectively became the operating law.
Pretty much, yeah. It became the standard interpretation.
Yeah.
This system enriched legal principles in a way that simply wouldn't happen, where a single institution holds the sole prerogative of justice. It drove constant refinement, innovation even.
That makes perfect sense. Okay, so let's move from the intellectual power of the jurist to the active administrative power of the magistrate, specifically the praetor.
The praetor, yes.
If the jurists interpreted the old law, the praetor essentially created new legal pathways where the old law was maybe too rigid or just silent on an issue.
Yes, precisely. The praetor's authority, which was exercised annually through his published edict, a sort of program for his year in office, was monumental.
Right, the edict.
He granted legal remedies, actions, effectively filling gaps or adjusting the rigor, the harshness of the civil law. He was the great dispenser of equity and procedural tools, a real innovator in his own right.
And his authority wasn't just about granting lawsuits. It was also about enforcing compliance, right? The procedure for a defendant who simply refused to participate in a civil case, that really shows the sharp edge of praetorian power.
Oh, it does. Absolutely. If a defendant in a civil case was indefensus, That means they wouldn't confess to the claim, but they also wouldn't formally offer defense.
They just ignored it.
Basically, yeah. They didn't incur an immediate judgment by default, which might surprise us today. Instead, they were immediately subjected to praetorian execution.
Praetorian execution, that sounds ominous. What did that actually entail?
It was harsh, no question. This process involved the missio in bona and the uneditio bonorum,
Meaning
meaning the immediate seizure of their entire property, everything, followed by its eventual sale to satisfy the debt or obligation. And this same immediate property seizing process was applied to a judicatus. That's a debtor who had already been formally judged liable, but still hadn't paid up.
So no messing around.
None. It highlights that the Roman system prioritized making sure the wheels of justice, once started, could not be ignored just by refusing to show up. The praetor ensured compliance through, well, the threat of financial ruin.
So the praetor enforced procedural compliance with, like, an iron fist.
You could say that.
But he also provided this critical safety valve for fairness through the exceptio, the exception.
Exceptio. That's crucial.
This mechanism seems to be where the abstract ideal of Roman law meets the practical desire for, equitable results.
Absolutely. The Praetorian jurisdiction was critical in developing this system of exceptions. They were procedural safeguards, really. They protected defendants by allowing them to raise a point of fact.
Okay.
That, while perhaps irrelevant to the strict civil law liability, made condemnation seem inequitable, unfair.
Can you give us an example, something that shows that necessary contradiction between the letter of the law and the spirit of the exception?
Sure. The classic illustration is the exceptio doli mali, the exception based on malicious fraud, dolus malus.
Okay, fraud.
Right. Imagine a situation. You sign a document, a formal stipulation, promising to repay a large sum of money to a creditor. Okay.
Got it.
Under strict civil law, any civil, your signature means you are liable. Period. End of story.
Makes sense.
But what if the creditor fraudulently induced you to sign? Maybe lied about the terms. Or worse, what if they never actually loaned you the money they promised in the first place?
Ah, okay.
So if that creditor then sues you based on that signed document, the praetor, through the exceptio doli mali, allows you to argue, hold on, condemning me, even though the contract is technically valid on its face, would be fundamentally unfair because the whole thing was based on fraud.
So the exception could basically nullify the strict law.
When equity demanded it, yes, it didn't erase the law, but it blocked its enforcement in that specific case. Fantastic example of that tension.
That dual approach, strict law, tempered by this magisterial equity, really is the hallmark of their legal sophistication, isn't it?
It really is.
Before we move on, there's a quick procedural point raised in the sources about the need for these complex courts rather than relying on, say, the popular assembly for all criminal cases. Why was that necessary?
Well, fundamentally, it was about volume and practicality. Sheer volume. Our sources stress that it was, and I quote, quite impracticable to keep the popular assembly in virtually permanent session just to handle every single criminal case that came up.
Right. You can't have the entire voting population constantly meeting for trials.
Exactly. The logistical nightmare of assembling the comitia, the voting assemblies, constantly meant there had to be standing courts, quaestiones perpetuae perhaps, and more complex procedures. This supports the idea, though admittedly it's a contested theory among scholars, of a necessary common law criminal jurisdiction existing alongside the assemblies just to manage the essential state function of judging major crimes. The people simply couldn't govern every single verdict. It wasn't feasible.
Okay, that makes sense logistically. Let's pivot now to a specific area of liability. Wrongful damage, or delict, governed by the famous Lex Aquilia. It sounds like this law was, well, ruthless in its economic assessment of harm.
Meticulously mathematically ruthless is a good way to put it.
Yeah.
In damage assessment under the Lex Aquilia, the law considered only the objective, quantifiable worth of the damaged property to the world at large.
Objective value.
Objective value. They explicitly and systematically excluded the owner's subjective personal feelings or any kind of special emotional value attached to the property. Sentimental value meant nothing legally.
What's the most powerful example of this sort of cold utilitarian approach in the sources?
Well, the example our sources provide is pretty grimly illuminating, actually.
Okay.
It says, if one person kills the natural son of another, and that son happened to be legally held as a slave, perhaps due to debt bondage or something.
Okay, I see where this is going.
The killer only pays the slave's market value, just the economic worth of that slave as property.
Wow. regardless of the father's feelings.
Completely regardless. It doesn't matter one bit that the natural father might have been willing to pay, I don't know, 1,000 times the market value to redeem his own child. That specific price, based on paternal affection, is legally irrelevant to assessing the loss under the lex Aquilia.
So the law is just laser-focused on the objective harm to the patrimony, the estate, the economic loss.
Precisely. The objective economic loss, not the subjective pain or grief of the individual owner.
That makes the system seem incredibly advanced in its objective economic calculus for the time.
It was, in a way.
Yet also profoundly detached from, well, human experience as we understand it.
That's the paradox. Did the lex Aquilia only cover direct intentional harm, though? Or did it extend further?
No, it wasn't just intentional harm. Liability under the lex Aquilia was also used extensively in cases of negligence. Carelessness.
Okay. Sometimes this was referred to generically as inuria or injury in the sense of wrongfulness, not just physical hurt.
And even defining the act of harm itself required intense scrutiny, didn't it? Like, the timing mattered hugely.
Oh, timing and intent were everything.
Yeah.
For example, if a person wounds a slave,
Yeah.
maybe injures them badly,
Right.
and then sometime later, maybe days or weeks later, kills that same slave.
Okay.
Roman law viewed this as two separate delicts, two separate wrongful acts.
Not one continuous event.
No. You'd have liability for the wounding and separate liability for the killing. This is critically distinguished from, say, multiple blows delivered in a single continuous attack,
Right.
which would just count as one action for the killing.
So the timing and the intent behind each action separated the legal consequences.
Exactly. It shows how minutely they dissected the sequence of events and the state of mind involved.
Okay, so we've established that Roman law was flexible, interpretive, and its application could be chillingly cold and economic. Now, let's turn to the actual mechanism of justice, the trial itself. What immediately strikes me, and what our sources really emphasize, is that prosecution seems to have been fundamentally a high-risk, private enterprise.
Here's where it gets really interesting.
I bet.
Yes, absolutely. Rome, and, borrowing heavily from Athenian practice here,
Right.
relied almost entirely on private citizens to initiate prosecutions. The state didn't really have a public prosecutor's office as we understand it today. There wasn't a district attorney figure.
So anyone could bring a charge.
In theory, yes,
Yeah.
any male citizen in good standing, but this meant that the accuser, who was often a wealthy or politically ambitious individual, was seldom motivated by purely, civic-minded altruism.
Right, it wasn't just about seeing justice done.
Rarely. Their own self-interest was often served by punishing a rival, maybe eliminating a political enemy, or simply gaining public notoriety and favor through a high-profile case.
And this must have made accusations, especially for things like political corruption like ambetus, bribery during elections, incredibly politicized acts, almost a form of political theater.
Absolutely. The courtroom was an arena, a stage. We see this so clearly in the rhetorical strategies employed by advocates like Cicero.
Yeah.
He, for instance, used arguments specifically designed to resonate with the popular imagination, the biases of the jury, perhaps. He famously argued in one speech that the Roman people hate private luxury but love public magnificence.
Clever. So target the defendant's lifestyle.
Exactly. Opponents in court were frequently denounced by emphasizing their perceived personal decadence, their luxurious villas, maybe their overly elaborate dinner parties, their fancy clothes, contrasting it sharply with the public grandiosity, the temples and aqueducts that the populace admired.
So it was a direct attempt to tap into popular moral resentment.
To secure a political conviction against an elite rival.
Yeah.
Absolutely. Pure political maneuvering dressed up as legal argument.
Okay, but this reliance on private prosecution must have created a need for some kind of check, right? Otherwise, it's just chaos.
Precisely. And that check was the terrifying penalty for bringing a false or malicious charge. Calumnia.
Calumnia.
Since political maneuvering was, let's face it, the norm, the state had to maintain some control over the process by ensuring there was severe risk for the ambitious or perhaps reckless accuser. You couldn't just throw accusations around lightly.
The risk was formidable then. It acted as a filter.
A very serious filter, yes. Unsuccessful accusers were punished for calumnia. Now, in the Republic, the penalty was, relatively speaking, milder. It resulted in infamia,
We'll come back to infamia, but essentially a loss of reputation.
a major loss of legal and social standing, yeah. Bad enough for a politician, it could end a career. But under the imperial period, the penalty escalated dramatically. It became a much more potent tool of state control wielded by the emperors.
How dramatic was that escalation? Can you give us a sense of that shift?
Oh, it became potentially life or death. We have this chilling record, mentioned in our sources, of an unsuccessful accuser who brought charges against the man who had become Emperor Septimius Severus.
Okay. Bad move.
Very bad move. This accuser, who was noted as being of the lower status, one of the humilior,
Right, status again.
was ultimately crucified when the accusation failed.
Crucified. For bringing a failed lawsuit.
For bringing a failed accusation against a powerful figure who then became emperor. The emperor saw informers, delators, and false accusers as destabilizing threats. Trajan, for example, took the extraordinary step of staging a mass trial of known informers in the arena.
In the arena, like for public spectacle.
Yes, resulting in the confiscation of their properties and their mass deportation. It was a purge. And Pliny the Younger, who witnessed it, described it with a certain chilling detachment as a beautiful sight.
Wow, beautiful sight. It sounds less like a legal process and more like the state ruthlessly reinforcing the hierarchy. The law itself being used to punish those who dared to target the wrong person.
That's a very astute way to put it, yeah.
Which brings us back to that central theme, status. If failure could result in crucifixion for the humiliores, did the elite, the senators and equestrians, enjoy a kind of judicial protection even in serious cases?
It certainly seemed to, especially within the Senate itself, which often acted as the high court for judging its own members, particularly in capital or politically charged cases.
So the Senate judged senators?
Often, yes.
Yeah.
And the sources suggest the Senate, drawn exclusively from the elite classes, was demonstrably effective at systematically favoring members of the senatorial order, protecting their own.
Especially when certain people weren't watching.
Exactly. The emperor's influence seems to have been a crucial variable in whether that favoritism was checked or not.
How so?
Our sources note that when emperors like Trajan, who is generally seen as fair but perhaps less interventionist in routine senatorial matters, showed little personal interest in attending these senatorial trials. The Senate was much more capable of exercising this internal protectionism. There was this continuous tension, this effort to protect the status of senators, to ensure they wouldn't lose their citizenship, their property, or their homeland, the absolute pillars of their elite status.
Right.
Due to imperial hostility or political attack.
Yeah.
This was especially true when the charges fell under the dreaded Maestas law. Treason, the ultimate political weapon.
So if the emperor was busy or looked the other way, the elite could kind of manage things amongst themselves. But if the emperor was present and invested,
the risk went up considerably for everyone involved.
Yes.
The trial truly was a political ecosystem, highly sensitive to the apex predator, the emperor.
This environment, then, where status was paramount, rhetoric was the key weapon, and the emperor's mood mattered. It must have created fertile ground for corruption, right? Even among the accusers and defenders themselves.
Oh, absolutely. The highly dramatic, high-stakes nature of these contests led to some incredibly complex forms of corruption. It wasn't just simple bribery.
Like what?
Well, accusers could be charged with taking money from the defendant to deliberately bungle the prosecution, or just drop the case altogether. A form of legal blackmail, really.
Okay.
Or, conversely, advocates might be accused of taking money from the accuser to ensure a conviction, perhaps by withholding evidence or presenting false arguments.
Wow.
But our sources reserve a special kind of condemnation for what they saw as the ultimate injustice, the absolute betrayal of the system.
Which was?
Taking money from a defendant with a solemn promise to get him acquitted.
Yeah.
And then condemning him anyway. Taking the bribe and still ensuring the conviction. That was seen as the deepest perfidy.
It's a snapshot of a highly mercenary, incredibly risky legal environment.
Totally.
Yet, despite all the systemic corruption and political maneuvering, the concept of equitas, equity, persisted. We talked about the exceptio.
Yeah.
Even if someone was technically guilty under the black letter of the civil law, the defense could still argue that condemnation would be inequitable. Why maintain this veneer of fairness in such a cutthroat world?
That's a great question. I think it's because the Roman legal system, for all its political manipulation, was fundamentally built on procedure. Formal procedure mattered immensely.
Right.
The exceptio provided a controlled, established way to acknowledge that the strict application of the aurorius civil could lead to an unjust or politically inconvenient result without actually having to overturn the law itself. It maintained the facade of procedural regularity.
So it's a way to bend the rules without breaking them.
Kind of, yes. It shows this profound tension. Rome wanted absolute procedure, rule following. But it also knew, pragmatically, that sometimes, for political reasons, economic reasons, or even genuinely equitable reasons, that procedure had to yield to a sense of fairness. often guided by the praetor's influence and his edict.
And that was essential for maintaining the credibility of the institution.
Exactly. Even if the outcomes were often heavily influenced or even dictated by status and politics, the forms had to be observed.
Okay, we've tracked the law from its interpretation by jurists, through the praetor's interventions, to the political battlefield of the trial itself. Now, let's look at the end game. The final, often terrifying consequences of a guilty verdict. What actually constituted a capital crime in Rome, and what kind of ritualistic severity was reserved for the worst offenses?
Well, capital crimes were those punishable by death, obviously. And they were generally reserved for crimes seen as striking at the heart of the Roman state or the Roman family. Things like treason, maestas, certain types of sacrilege, and importantly, parricidium.
Parricidium. Now, that's often translated as patricide, killing one's father. Was it broader than that?
Yes, much broader, especially in earlier periods. It could encompass the murder of any close relative, not just a father. It was murder within the family, seen as a particularly heinous violation of natural and religious law, the pietas tot kin. And parricidium definitely triggered one of the most infamous and symbolic penalties in Roman law.
That would be the pona cullae, right? The penalty of the sack.
Just the one.
It's a penalty that goes way beyond simple execution. It feels designed to, I don't know, erase the individual entirely from existence.
That's exactly the point. Poena culli was a specific, highly ritualized punishment, pretty much reserved for parricide, because the crime itself was considered so fundamentally unnatural. A crime against the very foundation of Roman society. The family unit, the familia.
So what did it involve? The details are gruesome.
They are. According to the sources, the condemned person was first beaten with rods, typically blood-red ones. Then his head was covered, sometimes described as being enclosed in a wolfskin bag, maybe symbolizing beastliness.
Okay.
And then he was sewn into a large leather sack, the cullius. Critically, he wasn't alone in the sack.
Right, the animals.
Yes, often live animals were sewn in with him. Typically a dog, a snake, a monkey, and a rooster or cock.
Why those specific animals? Is there symbolism there?
Scholars debate the exact symbolism, but it likely represented the monstrous nature of the crime, the complete break with human society, and perhaps even the violation of different aspects of nature or domesticity. These animals were seen as either base or having their own symbolic weights. The combination was meant to be horrifying.
And then the sack itself.
The sack, sealed with the condemned and the animals inside, was then thrown into water, usually the sea or a deep river, to drown.
The symbolic meaning is just staggering. Denied proper burial, denied contact with the natural elements of earth and fire, and killed in the company of beasts. It's like a complete erasure of their status as a human being, designed to horrify everyone.
That's the key. It was a deliberate act of, effectively, damnatio memoria, condemnation of memory, but in a physical ritual sense. By denying the body, earth and fire, the traditional elements of burial or cremation, the Romans ensured the condemned was ritually removed from the community of both the living and the dead. It underscored the absolute severity of violating the sacred bond of the family.
Chilling.
Chilling.
Okay, so beyond outright execution, the loss of social standing itself was a devastating penalty, wasn't it? Often accompanying whatever the formal punishment was. This brings us to the concept of infamia. What did infamia actually mean for a Roman citizen day to day?
Well, condemnation in almost any significant criminal case, and even in some civil cases involving disgrace like fraud or bankruptcy, invariably carried infamia in addition to any other penalty like a fine or exile.
And infamia was?
It was essentially public disgrace made legal, social and legal dishonor. For a Roman citizen, particularly one of the upper classes, it was a profound blow that severely restricted their public life.
How so? What couldn't they do?
An infamous person typically lost the right to hold public office, the right to vote in certain assemblies, the ability to represent others in court, and, critically, often lost the capacity to give valid testimony in court in certain types of cases. Their word was legally tainted.
So it was a form of civic death, almost. They remained citizens, technically, but their public rights and social standing were just gutted.
That's a good way to put it. Civic death. Their public persona was destroyed.
And we see that same underlying logic in the Greek world too, right? Which suggests this idea of civic worth being tied to legal standing was pretty fundamental across ancient legal thought.
Oh, indeed. We see really strong parallels with the Athenian concept of atimia, which literally means loss of honor or rights, disenfranchisement.
And atimia was used similarly.
Yes, it was severe social punishment in Athens. levied not just against those convicted of serious crimes like treason or cowardice, but interestingly, even against those who failed to pursue public suits they initiated or failed to pay public debts. It demonstrated that active, responsible civic participation was almost a legal expectation. Failure meant disgrace.
So this shared ancient principle highlights the really high social cost of being deemed a bad citizen, which infamia represented in Rome.
Exactly. Your legal standing and your social reputation were tightly bound together.
Okay, now let's look at how the law defined specific, maybe more common, non-capital crimes. We need to explore the incredible complexity involved in defining theft, furtum. It seems to hinge entirely on the person's intent.
Oh, the definition of furtum was indeed meticulous. It really demonstrates the Roman jurist's obsession with the mental element, animus ferandi, the intention to steal.
So it wasn't just about taking something.
No, not at all. The physical act of taking, contractatio, was necessary but not sufficient. If a man took something genuinely believing it had been abandoned by its owner, he was not guilty of theft, even if he was mistaken.
Okay.
Similarly, if he found property lying about, say, a lost wallet, and took it with the honest intention of returning it to the owner, even if he didn't know who the owner was yet, he was not guilty of furtum.
So the key was the dishonest intent. The intent to appropriate the property for profit or gain, knowing it belonged to someone else.
Precisely. The animus lucri faciendi, the intention of making a gain, was often considered central. Without that dishonest intent, it wasn't theft in the eyes of Roman law.
That's a crucial distinction, separating accidental taking or mistaken belief from actual criminal action. But the liability could get incredibly convoluted, couldn't it? Especially when the stolen property itself changed or were stolen multiple times.
Oh, yes. The jurists love these complex scenarios. Take the example of the maturing slave, which the sources discuss.
Okay, what happens there?
Let's say a thief steals a young slave child. That child then grows up in the thief's household over several years, becoming an adult slave.
Right.
The law deemed the thief to have stolen the adult slave just as surely as they stole the child. It was viewed as one continuous, ongoing act of theft, furtum continuum.
So the liability continues as the property changes.
Yes, and critically, the thief is liable in a civil action for duplum, twice the value, and it's calculated based on the highest value the slave ever reached while in the thief's possession.
Wow, so the owner actually benefits from the slave's growth while stolen.
In terms of the penalty calculation, yes, it maximized the thief's liability over the entire period of the theft. It's a strong disincentive.
That definitely maximizes the liability. Okay, what happens when the criminal act is compounded? Like, when a second thief comes along and steals the already stolen item from the first thief, who gets to sue the second thief?
Ah, yes. This gets into the complex concept of who has a sufficient legal interest in the property's safety to bring the action for theft, the accuser.
Okay.
So, if a second thief steals the item from the first thief, the rule developed that only the original owner can sue the second thief for theft.
Not the first thief, even though it was taken from their possession.
Generally, no. The first thief, despite being in physical possession, cannot sue the second thief using the actio furti.
Why is that distinction necessary? I mean, the first thief certainly has a practical interest in recovering the property they stole.
They have a practical interest, sure, but the law only recognizes the honest interest of the true owner, or someone holding it legitimately, like a borrower responsible for its safety. The first thief's possession is rooted in furtum, in a wrongful act. Therefore, his interest is considered dishonest, illegitimate. The jurist Quintus Mucius, who heavily influenced this area of law, argued that the right to bring the theft action should only rest with the person who suffered the actual loss, and whose claim is untainted by their own criminal intent regarding that specific item.
So the law prevents the first thief from using the legal system to profit from their own crime, essentially.
Exactly. The first thief is still liable to the original owner, of course, for the initial theft, but he cannot turn around and use the actio furti himself as either a shield or potentially a source of profit against a subsequent thief. It's a mechanism designed to ensure that the law doesn't inadvertently appear to legitimize or protect criminal possession. It keeps the focus on the rights of the legitimate owner. Hashtag outro.
Wow. This deep dive has really shown Roman justice to be this, well, dynamic, contradictory, and utterly captivating system. Just fascinating.
It really is.
We've seen the incredible interpretive power of the juris responsa, constantly stretching and shaping even foundational texts like the 12 Tables.
The living law.
And the sort of genius of the praetor in applying equity through mechanisms like the exceptio, bending the rules for fairness,
The crucial function.
and then the whole high-stakes, incredibly dramatic nature of accusation, where the risk of calumnia could lead to absolute ruin or even death, especially, as we saw, for the non-elite.
That status difference is key.
Absolutely. What really surfaces from all these details, all these complexities, is a fundamental insight, isn't it?
I think so.
Mm-hmm.
And it is that Roman law, in practice, was less a pure pursuit of abstract universal justice
Right.
and far more a meticulously organized, highly sophisticated system for maintaining social order and, maybe above all, political hierarchy.
Hierarchy seems central.
It does. Even the application of equitus, of equity, through the praetor's edict was ultimately deployed within a system that structurally reserved the most lenient procedures and the greatest protections for the elite senators and equestrians.
While reserving things like public spectacle executions, crucifixion for failed accusations, and the devastating social blow of infamia more readily for others.
Exactly. The entire legal process was just intrinsically shaped by the political dynamics of the Senate, the influence of powerful families, and looming over it all, the will of the emperor.
So what does this all mean?
Well, I think it means that the Roman courtroom was arguably the most potent battleground in the city, more than the battlefield sometimes. It was where reputations were forged, alliances tested, and enemies destroyed, all through legal maneuvering and rhetorical skill.
And that reliance on private citizens to prosecute,
Yes,
coupled with those incredibly heavy penalties for getting it wrong, for calumnia, it created this unique legal culture, didn't it?
it certainly did. A culture where the wealthy and well-connected were simultaneously the most powerful potential accusers,
Because they had the resources and clout.
and the best protected defendants because they had the resources for top advocates and the political connections to influence outcomes, perhaps even within the Senate itself.
Which leads us to our final thought, something for you, the listener, to consider. Was Roman justice, then, simply a highly regulated, incredibly high-stakes form of elite social warfare?
Social warfare codified.
Where the rich and powerful use sophisticated legal terminology and procedure primarily to fight their political battles, secure advantages, and reinforce their position at the very top of that rigid hierarchy?
It's a challenging question. It certainly forces us to look beyond the image of Roman law as this purely objective, rational system, and reminds us that law is always, and perhaps everywhere, deeply intertwined with and often an instrument of power.